Hello, my name is Amin. I go by Sam. I'm the principal attorney here at Amin Law in San Francisco, California. Welcome to the fourth segment of PPP loan fraud. As discussed in my previous videos on my YouTube channel, a person charged with PPP loan fraud may face serious criminal and civil penalties. One of the most common criminal charges for a PPP loan fraud is 18 U.S.C. section 1344, commonly known as bank fraud. The prosecutor must prove the following elements beyond reasonable doubt in order to convict a defendant of bank fraud. Number one, defendant knowingly executed a scheme or ploy to defraud a financial institution, or that defendant knowingly executed a scheme to obtain money, funds, or other property owned by or under the control of a financial institution by means of material, false, or fraudulent pretenses, representations, or promises. Number two, defendant intended to defraud a financial institution, and the financial institution was insured by FDIC, which is the Federal Deposit Insurance Corporation, or chartered by the United States. Now, to act with intent to defraud means to act knowingly and with the intention or the purpose to deceive or to cheat. In considering whether a defendant acted with an intent to defraud, a jury may consider, among other things, whether a defendant acted with a desire or a purpose to bring about some gain or benefit to oneself or someone else at the expense of a financial institution, such as a bank, or with a desire or purpose to cause some loss to the financial institution. The most common defense to bank fraud is lack of intent. One cannot be convicted of bank fraud unless there's evidence beyond reasonable doubt that the defendant specifically intended to commit fraud. Again, this can be a difficult element for the federal prosecutors to prove just because it is hard to determine with a certainty what another person was thinking when she or he acted a certain way. For this reason, lack of intent can be a very powerful defense. A conviction of bank fraud carries a fine of up to $1 million and or up to 30 years in prison. And that's right, bank fraud carries a hefty potential fine and a serious prison time up to 30 years. Bank fraud is not a crime that the United States government takes lightly, a fact that is not surprising given the policy behind Section 1344, which is to, quote, protect federally insured banks from fraud. End quote. The DOJ views the bank fraud statute as a flexible tool. It has stated that the bank fraud statute allows the United States to prosecute fraudulent conduct not otherwise the subject of a specific criminal statute. Think PPP loan fraud. Now, the statute, in other words, essentially is a catch-all for any activity that may defraud a federal bank, and it is quite far-reaching in scope. This broad reach is particularly relevant in our increasingly global economy. The legislative history of the bank fraud statute also indicates a congressional intent that the bank fraud provision have extraterritorial reach and that the offender may be prosecuted if present within the United States, even if the fraud or the fraudulent conduct took place outside the borders of the United States. Thank you for watching. I have a team of professionals who are ready to assist. All you have to do is pick up the phone and give us a call. If you found this video educational, I'd greatly appreciate it if you can share it. Of course, don't forget to like, comment, and subscribe. Bye-bye.